first things you might want to try. Oh, I wasn't going to record the intro.
Okay. Thanks for joining us today. We have a very interesting session on the fiduciary duties of nonprofit board members, and we're really pleased to have Laurie Dunsmore here. She is a well-respected person involved in the world of tax-exempt organizations. She's a partner at Perkins Coie and a volunteer with Washington Attorneys Assisting Community Organizations. She has over 20 years of experience representing individuals, businesses, and tax-exempt organizations in a variety of charitable, wealth transfer, business succession, and federal tax matters. Laurie regularly works with individuals and tax-exempt organizations to address a wide range of tax and state law issues. She has spoken and written about numerous issues related to nonprofit governance and compliance matters, and has worked with a variety of tax-exempt organizations to provide training for board members and officers. I want you all to welcome Laurie, and thanks for being here today.
Real quickly, I want to go through the facilitators we have today. Carolyn Peterson is unfortunately out sick, and Jennifer is unavailable as well. So we have Diane stepping in. Thank you very much, Diane, for helping out today. Your technical support is Joe Olivar and Jeremy Stroud, myself. And I put our emails into the chat box if you need us. And this is brought to you by the Office of the Secretary of State, Washington State Library Division, and by the Institute of Museum and Library Services. Before we get started, can I please have everyone type in their name, their library organization, and if you have more than one person that you're logged onto your computer with you, can you please type that out into the chat for us as well? All right, thank you, everyone. Now, as Diane said earlier, Laurie, take it away.
Hi, Diane. Thank you for that lovely introduction. Hello, everyone. This is Laurie Dunsmore. Would you raise your hand if you can hear me speak okay? Excellent. I have not used this program before. Jeremy has been training me, so I thought I'd try this out. Excellent. Great. What we're going to do today is talk about the fiduciary duties of a nonprofit board member. How many of you serve on a board of directors for a nonprofit, whether it's a charity down the street, even a homeowners association? If you serve on a board of a nonprofit, please raise your hand. Okay. What I'm going to do is cover issues about serving on a board with the hopes that by the time we're done, you'll all want to go out and serve on the board of a local nonprofit. It is a fascinating job, very rewarding, and at times a little tricky. First of all, let's start talking a little bit about charitable organizations, charitable nonprofits. In 2011, individuals gave nearly $218 billion to charity. If you count all charitable contributions from private foundations and others, the number goes up to almost $300 billion. Charitable organizations are a huge business in the United States. There were over 1.6 million tax-exempt organizations in the United States. Over 1 million are public charities, such as United Way, Red Cross, Susan G. Komen Breast Cancer Foundation. Those are all examples of public charities. They account for almost 10% of the wages paid in the United States, and over $1.4 trillion in revenue. So remember, about $300 billion of that $1.4 trillion came in the form of charitable contributions. another 70% came in the form of program-related services. In the state of Washington alone, we have several thousand 501c3 organizations, and about 90% of them are have revenues of $800,000 or less. If you were going to guess, how much do you think people in Washington gave to charities last year in the state of Washington? What would your guess be? Write in if you have any guesses. Over 5 million? 5 million? Any other guesses? I think you need to go up quite a bit. Washington's a lot more generous than you think. So total contributions from people within the state of Washington. $1 billion, 25 million. We need to go up from $1 billion in the state of Washington. Up. Yes, that is right, up. $3 billion is exactly right, Jeremy. Good job. If I was there, I'd toss you a piece of candy or something. That's exactly right. If you go to the website for the Chronicle of Philanthropy, there is a section on how America gives, and it lets you look state by state. So you can look at Texas, for example, and any other state, city, county, and find out what contributions are. It's a fascinating website. So I encourage you to check it out. So now that we know that this is a very big business, it's important to understand what it means to be a director, because there is a lot of economics attached to it. Let's talk about what this really means. So over the next hour, we're going to talk about what it means to serve on a board from a legal perspective. There are many benefits to serving on a board. It's very rewarding, but we're really going to focus on the legal perspective today and what our key fiduciary duties are as board members, what we expect from board members, and we probably actually won't touch on a governance review today because I don't think we'll have time. What we want to do is Corinne, the name of the website, it's the Chronicle of Philanthropy, and I know there's a way, Jeremy, to put this website into this program, but I can't remember how.
Well, if we don't do a web share, we can just type it into the chat. Just type the URL over there, and it will automatically link it for us.
You're so smart. Okay.
I can look it up and do that if you would like.
I thought I could type it in, but I mean I thought I could paste it in. So it's the Chronicle of Philanthropy and How America Gives, and if you could do that, Jeremy, that would be fabulous.
Is that philanthropy.com?
Yes. And then type in How America Gives, and it'll pull you to this survey. It is a fascinating thing to look at. Thank you, Diane. See, a bunch of librarians, you know how to do this better than I do. This is a great website, very fascinating. Okay, we're going to talk about fiduciary duties. Fiduciary duty is an obligation you have by virtue of your position as a member of a board of directors. And the first duty we want to talk about is the duty of obedience. The duty of obedience requires a director of a nonprofit to understand and carry out the mission of the nonprofit corporation in a lawful manner. Notice lawful manner. One of the things I like to do when I'm talking to people is ask, if you're on the board of directors, can you give me your 30-second elevator speech? Can you succinctly describe the mission of your nonprofit? And if you're serving on a board, you should be able to do that. And it's fun to talk about that with people and hear what they're doing. The duty of obedience is really a generic term that encompasses the other two duties that we'll spend most of our time talking about, which is the duty of care and the duty of loyalty. So the duty of care is a duty that requires a director of a nonprofit to act with such care, including reasonable inquiry as an ordinarily prudent person would use in similar circumstances. I've given the Washington statutory site for this. If you are from another jurisdiction, virtually all states have these same duties: the duty of obedience, the duty of care, and the duty of loyalty. So the site for Washington is RCW 24.03.127. To act with the duty of care means that you should attend the board meetings. You should gather and review relevant information. You should use reasonable judgment in making decisions. This duty of care means that you need to show you care by being an active participant. You should not miss meetings unless it's an exceptional reason. You need to review materials sent in advance. If materials aren't sent in advance and you're expected to review things at the meeting, you should speak up and say, no, we need to do this right. Please send the materials in a way that I have a time to review it and discuss at the meeting. So make sure that you attend the meetings, you review relevant information, and you use good judgment. Good judgment does not mean that you need to be perfect. Good judgment means that you need to use your best efforts to do things right. But again, it does not mean that you have to be perfect. The duty of loyalty requires a director to serve in good faith and act in the best interests of a nonprofit corporation. You should put the best interests of the nonprofit corporation above your own personal interests when making decisions. So if you're on the board of a alcohol rehab facility, and you're trying to decide where to put the latest rehab center, you should do that thinking about what's in the best interest of the rehab center, not how close it is to your personal residence, for example. Other ways that comes into play is maybe you're a director on a local park board, and they're talking about putting in a soccer field or a softball field, and they're mutually exclusive. You should focus on which is the best for your nonprofit, not which is best for your children who play sports. We can get into many more specifics, but that's the gist of the duty of loyalty. You should be aware of potential conflicts and act openly and honestly in dealing with those conflicts. Disclosure and reasonableness are the key factors. I'm working with an organization right now. I'm attending their board meeting on Thursday morning, and they have a new board member that has raised a lot of conflict of interest issues. And it's been interesting to watch this board go through dealing with those conflicts. They have listened to the issues raised by the new director, and they have talked about a plan of action, and they are reviewing their conflict of interest policy. So this is a good time to talk about what is a conflict of interest. A conflict of interest exists when a director has a material personal interest in a transaction or a proposed transaction to which the nonprofit corporation could be a party. Can anyone give me some examples of potential conflicts of interest? You can either speak or put it in the chat box. What are some examples? What would you think might be a conflict of interest? So one example is an organization buying property owned by a board member. Rita, that is a perfect example of a conflict of interest. It happens all the time. Doesn't mean it's illegal, but it's certainly something that we need to carefully look at, because if it is inappropriate, there can be huge consequences both to the nonprofit and the board member. Teresa, owning a business that the board does business with, that's another example. I work with a nonprofit where on the board is the insurance agent who brokers the insurance for the nonprofit. There's even someone who owns a winery that sells wine to the nonprofit. Both of those are ones where there are conflicts of interest. Beth, spousal relations with staff is another good issue. You need to disclose that information, and we'll talk about that when we talk about the conflict of interest policy. There are many ways that there can be conflicts of interest, and again, it doesn't mean that there's something inherently illegal or unethical. It just means you have to have procedures in place to deal with those conflicts so that both the nonprofit and the board member stays out of trouble. One of my favorite quotes, and I think it's partly because it's so short I can remember it, is "No conflict, no interest." John Doerr is a venture fund capitalist in the Silicon Valley, and he's very clear that if there's no conflict, that probably means there's no interest. You're involved in what you're interested in, there's more likely to be conflicts, so you want to just recognize that and deal with it. Asking the board to do exclusive business with a board member's company. That's actually a very tricky one. The word exclusive makes me particularly nervous. I'd want to think a lot before I agreed to do something like that. So that's a good one. So a conflict of interest does not automatically mean the conflict is detrimental to the nonprofit corporation. For example, you could sell property to a nonprofit for 20% less than fair market value. Does that pose a potential conflict of interest? Yes, it does. Is that detrimental to the nonprofit? Of course it's not. There are many things that insiders, people with a position of power, can do with a nonprofit that is actually of great benefit to the nonprofit, but you still have to deal with the conflict of interest policy to make sure that you are fulfilling your fiduciary duty of loyalty. One of the things, just to bring this home, is to talk about why it's important to follow your fiduciary duties and make sure you have a clear conflict of interest policy that everyone understands and adheres to. And the reasons are primarily personal and altruistic. Altruistically, you want the best to happen for the nonprofit. From a personal standpoint, you want to minimize your own liability risks. So it's important to identify and address conflicts of interest because state law says you should. Those are your fiduciary obligations, the duty of loyalty and the duty of care. The state of Washington and many states have fantastic provisions to protect directors and officers serving on boards. However, as is typical in many states, Washington says that you are not, your liability is not limited as a board member if you personally receive a benefit in money, property, or services to which you're not legally entitled. Now that makes perfect sense. So for example, if you embezzle money, you're not entitled to it, and of course your personal liability is not going to be limited. You will be expected to pay back that money. If you receive excess salary, more than you are reasonably worth, you're not entitled to that money and it should be paid back. So although there are great liability limitation provisions in statutes in Washington and many other states, they will not protect you from inappropriate behavior, which is hopefully not surprising. So when we talk about minimizing liability by identifying and addressing conflicts of interest, we talked about it was important from a state law perspective. It was important from adhering to your fiduciary duties. It's also important because it is against IRS law, Internal Revenue Service, Internal Revenue Code law, to engage in private inurement. And that is where an insider takes advantage of the charity. And so that is against the rules. And it's important, if you have a conflict of interest policy, it can help you avoid falling into that trap. You can also, it's also important because you make representations on your tax-exempt application when you're applying to be a charity that you will not violate conflict of interest rules. Every year when the nonprofit files its tax return, those same representations are again being made each year. And one of the best reasons for not violating these rules are the intermediate sanction rules. That's in Code Section 4958, so Internal Revenue Code Section 4958. And I want to spend just a couple minutes talking about this rule. Has anybody heard of this rule before? If you have, raise your hand. For those of you who serve on nonprofits or who may serve on nonprofits in the future, this is a rule you will want to remember. So Code Section 4958, and this rule says that for any public charity, if someone in a position of power, the legal term is a disqualified person, but let's say someone in a position of power has a relationship with the charity where the person in the position of power receives an excess benefit, something more than they should, there is a big penalty. So, for example, if a piece of property the board member owns is worth $100,000 and they sell it to the charity for $200,000, that's an excess benefit. And believe me, believe it, that does happen. Let's say you have compensation of $50,000 and the IRS thinks you should only be paid $25,000. Well, that extra $25,000 of compensation is, again, an excess benefit. What if you are buying a piece of property from the charity and you pay $100,000, but it's really worth $1 million? Again, you think this is outrageous, and it is, but it really does happen, and that's why this code section came into play back in the mid-90s. Before that, what happened was the president of United Way back in the mid-90s received $1 million compensation. Does anybody remember this story? If you do, raise your hand. Oh, yeah. Good job. So the head of United Way, the National United Way, was receiving $1 million compensation, and some of the people in Congress said, no, 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 this is outrageous. This is just wrong. And they said, IRS, do something about this right now. And the IRS said, look, Congress, we have two choices. We can ignore the compensation and do nothing, or we can revoke United Way's tax-exempt status. Well, what do you think happened? Well, the choice was they ignored the issue and instead let United Way keep its tax-exempt status. But because of that, Congress passed the rules for Code Section 4958, and they came in with an intermediate sanction on nonprofits behaving badly. So what this rule does, so listen up, it's really important. For a public charity, if a person in a position of power receives an excess benefit, that person is going to have a tax of 25% on that excess benefit. So again, let's say that you have a piece of property worth $100,000, you sell it to the nonprofit for $200,000. How much is that excess benefit? It's $100,000. If there's a 25% excise tax, that means the excise tax is $25,000. So that board member has to pay the IRS $25,000, and then it has to repay the charity the $100,000 excess benefit. So that has to go back to the charity. And then if this doesn't happen within 12 months, there is an additional 200% penalty levied against the disqualified person, that person in a position of power. This is a shocking penalty. Is it being used by the IRS? Yes. What does it mean for the other board members on the board? If you sit on the board of a nonprofit and it buys a piece of property for $200,000 that's worth $100,000, do you think the other board members might have some problems? Raise your hands if you think yes. That's right. They will have problems, and those problems are significant. So if the other board members, the ones who approved this transaction, did not follow the conflict of interest procedures and weren't careful about this, those other board members who didn't benefit from this property purchase at all will also face a penalty. And those board members will share a penalty on a joint and several basis, which means the IRS doesn't have to go after everybody equally. It can go after just one or two board members that approved the transaction rather than all the board members that approved the transaction. And they will share a penalty. And then if they don't make sure the transaction's fixed within that 12-month period, they face another penalty. The question is, who determines what is excess? The rest of the board, a staff person, the IRS? That's a fabulous question. And the answer is that ultimately the IRS is making that determination if you're audited, but on an upfront basis, it's the board. It's the board's job to make sure that the purchase price, the compensation, whatever is going on is reasonable. So they need to look at comparables, they need to do due diligence, they need to find out information and make a determination. And then if they do this all in advance and they do it properly following a good conflict of interest policy, what happens is if they are audited, then the IRS has to prove that the transaction was in excess. If they don't follow those procedures carefully, then what happens is if they're audited by the IRS and they haven't done that work in advance, then the burden of proof is in favor of the IRS and the board has to prove it's reasonable. So that's a little confusing. Basically, if you do your work in advance, the IRS has to prove that there is an excess benefit. If you don't do the work in advance, you have to prove there was not an excess benefit. So that's a motivation to do your work up front. Let me know if you have any questions there. Again, this is really important if you work on the board, if you are on the board of a nonprofit, or if you are the staff of a nonprofit. Make sure you pay attention to these rules, and you shouldn't get into trouble if you do your due diligence and make sure things are reasonable, but this is a code section the IRS does utilize. Other reasons you want to do the right thing, there are self-dealing rules for private foundations, Sarbanes-Oxley Act, increased actions by attorney generals around the country, and you want to comply with various good governance guidelines, and one of the things that's most compelling is you want to avoid negative publicity. I have one client in particular who said, Laurie, make sure I never end up on the front page of the newspaper for doing something wrong. And that's their litmus test. Even if they've done it right, if it might appear negative, they don't want to proceed. So you want to follow these conflicts of interest policies for many reasons. And one of the examples was increased action by attorney generals around the country. So I wanted to take just a moment before we go into more examples of conflicts of interest to talk about one case in New York. And in this case, the nonprofit was the Educational Housing Services, and it was a nonprofit to provide low-cost housing to students and faculty members of New York City colleges. And it came under scrutiny by the New York AG, and the state determined that the housing group was offering overly generous compensation to the CEO and founder of the nonprofit, and further said that the CEO and his wife were siphoning off millions of dollars for their own use through an affiliated company that was doing business with the nonprofit. What particularly bothered the Attorney General was that the board of directors wasn't doing a good job in overseeing the charity. It didn't ask tough questions. The board didn't follow its fiduciary duties. The board didn't question the deal between the nonprofit and the founders' affiliated companies. And the Attorney General said it was particularly troublesome that the board allowed the CEO to control the flow of information, and that the trustees did too little to verify the accuracy of the information. So if you recall, one of the things that we talked about was the duty of care requires us to act with proper care. We should attend meetings, gather and review relevant information, use reasonable judgment. And what the AG's office was saying here is, you know, they may have attended the meetings, but they really didn't focus on, they didn't ask the tough questions. They didn't get the right information. They let the CEO filter what they saw to too much of a degree to be appropriate. And as a result of that, the charity board members, so these board members who approved this, and then the Scotts, who were the founders of the nonprofit, paid an aggregate of $5.5 million in penalties to the state of New York. The board members themselves, so not the founders, but the other board members, paid $1 million collectively in penalties. And then the founders paid $4.5 million. Then a variety of things had to be repaid to the charity. And then what do you think will happen after that? Because that was the state of New York's Attorney General's office. What do you think will happen next? Any ideas? Prosecution. Well, I think prosecution could happen for a couple of them. What about IRS Code Section 4958? I think the IRS will be the next people investigating, exactly. The IRS will be the next people investigating these individuals. So they've already paid $5.5 million to the state of New York. Next up could be a 25% penalty on the founders and a $20,000 penalty on the remaining board members, plus a repayment of all the excess benefits or a 200% penalty. This is not over for the Housing Corporation of New York. So this is why you want a good conflict of interest policy and you want to follow the rules. So let's talk about some of the other examples of conflicts of interest. A business owned by a director sells computer equipment to the nonprofit corporation. Is that a conflict? Yes. Is it bad? Not necessarily. Depends upon the price of the computers. What should the board do to make sure this is a good deal? Any ideas? Get bids? Yes. That's absolutely right. If you get bids, you are protecting yourself as a director and you're protecting the nonprofit and you're fulfilling your duty of, would it be care or loyalty? Or both? Yeah, I think you as a director are fulfilling your duty of care to make sure that this is a reasonable price. What about the insurance agent who's also a director and sells insurance to the nonprofit corporation? Is that a conflict? Yes. Is it inherently bad? No, it is not. What should you do to make sure it's reasonable? Again, you get bids, you do due diligence, you look at comparables. What about when the nonprofit pays the president compensation? Is that a conflict of interest? Yes. What are some ideas on how to make sure that the compensation is reasonable? If you sit on the board of a nonprofit that's paying compensation to its leader, what would you do? You might not go get bids. Research comparable organizations, excellent. Should be a minimal amount just to cover things like travel, find comparables, poll other local boards. You want to find those comparable organizations. You want to look at how much time your president is going to be devoting to the nonprofit, what experience they have, what they will be doing, and what other nonprofits pay similarly situated people. Where can you find that information? One idea is already here, poll other local boards, which is great. How else can you find that information? You can look at 990s, WSL for libraries. There are many compensation surveys available. Philanthropy Northwest has surveys out here. GuideStar is a wonderful organization. If you go to www.guidestar.org, that lists all 990s filed within the United States. It is a fabulous website. If you're asked any questions about nonprofits as a librarian, I encourage that to be one of the first places you go. Again, it is, oops, thank you, you're ahead of me, Teresa. GuideStar.org. You can look at all the tax returns for organizations. They have compensation surveys that will help you check for salaries. You can parse the information by state, by type of organization. It's absolutely fabulous. Going on, information obtained from the nonprofit corporation allows a director to make decisions on the sale or retention of personal assets. That's an indirect conflict, and it's a little tricky. And this is what fiduciary duty is this conflict focusing on? Is it the duty of loyalty or the duty of care? Any ideas? It's the duty of loyalty. You have a duty of loyalty, and if you are, it's not really the duty of care because it probably is not going to impact the success or failure of the nonprofit perhaps, but there is a duty of loyalty. If you know some insider information that allows you to make a good judgment on the sale or retention of property. I'm not saying the sale or retention of property involving the nonprofit, but outside of the nonprofit. Like a park's going in and you know it'll increase the value of your property, or a drug rehab facility is going in and you know it'll decrease the value of your property, and you take actions based on that information. Another interesting conflict that comes into play is where you sit on more than one board. And the boards have similar goals or maybe competing goals. How do you manage that? And you have to be very careful when you sit on multiple boards to make sure that you are following your conflict of interest policies for both boards, that you understand what you're doing, when you're doing it, and that you keep confidential information confidential. Another potential conflict of interest is when a nonprofit loans funds to an officer, director, or other key player. Is that okay to do? Can you make a loan to an officer, director, or other key player? I agree, it is not a good idea. And the answer is, within the state of Washington, there is a statute that prohibits loans to officers and directors. Doesn't matter if the whole board agrees. Doesn't matter if it's for 8% interest, which would be very high. It does not matter. You cannot make a loan to an officer or director. It's illegal in the state of Washington currently. If a nonprofit board does loan money to an officer or director and that officer or director does not repay the loan, guess who will be liable for that loan? Any ideas? The entire board. That is correct. So this is a motivation to make sure you get this one right. I look at a lot of bylaws for nonprofits, and I often see provisions in the bylaws permitting loans to officers and directors, and it, again, is simply not allowed in the state of Washington. Doesn't mean if it's a good reason, doesn't mean if it's a good interest rate. It's just not allowed. We are working currently on revising the nonprofit statutes in Washington. This is a very, very exciting project. And one of the things that we are still considering is whether we should allow the nonprofit to make loans for a small amount of money to officers, for example, to relocate to their new position. And the answer is we might allow that if it's a reasonable interest rate and if there's good security. Does the IRS, does the Internal Revenue Code allow you to make loans to officers, directors, or other key players? Raise your hands if you think the IRS allows those loans. How many of you think the IRS does not allow those loans? Okay. Drum roll. Da-da-da-da. Okay. The IRS does allow loans to key players, to officers, directors, and key players, as long as the terms of the loan are reasonable. So this is where state law and federal law differ. So again, federal law will permit loans as long as the interest rate is reasonable between a key player and the charity. Okay, we've been talking about this, but it's so important, so now we're going to go over the details. How should conflicts of interest be addressed? The overall goal should be to clearly document that the potential conflict of interest was disclosed to the board and that the board made its decision based on the fairness of the transaction and in the best interests of the corporation. Does someone have a question that I'm supposed to answer?
I think I forgot to lower everyone's hand.
Do you have a question?
My apologies.
Okay. So the best way to avoid a conflict of interest is to adopt a conflict of interest policy. There are sample policies on the WACO website. Teresa, if you could put that in, WAACO.org. There are sample policies there, including an IRS form of policy that the IRS has approved. So if you're a nonprofit, if you're ever involved with a nonprofit and it does not have a conflict of interest policy, you will want to adopt one. First, it will keep you out of trouble. Second, the IRS really wants you to have a policy. And third, you'll be disclosing on the annual tax return for the nonprofit whether you do have a policy. So you want to have a policy. So again, preemptive steps. Adopt a policy, review the policy annually. It's not good enough just to adopt a policy and never look at it again. The board needs to review it annually and ideally on an annual basis, whether it's at the annual meeting or some other time, receive back from each board member a written certification saying that they've read the policy, they've understood the policy, and that they have and will comply with the policy. This is very important. And then there should be a point person on the board responsible for gathering and maintaining this information. And if someone knows about a conflict and they don't think it's been disclosed, they should raise that issue. This happens a lot. I worked with an organization that has 75 board members, way too many board members, and I knew many of them had conflicts. Of examples we've talked about, one sold wine to the nonprofit, one was their insurance broker, one was a real estate person, one was an accountant. They all had relationships with the nonprofit, and when we had them sign the annual certifications, only one board member out of those 75 said that there was a potential conflict. The rest did not, even though there were potential conflicts for many. So there's a lot of education that needs to take place on this subject. When you do go to adopt a conflict of interest policy, the overall objective is to make sure that you're protecting the interests of the nonprofit when it's contemplating entering into a transaction with a key player. You want to make sure that what you're doing is for the benefit of the nonprofit. So who should be covered by the policy? This varies organization by organization, but it should at least be the directors, officers, and key players. I work with an organization, a public charity involved in science, technology, engineering, and math, and many of the employees are involved in making grants to other organizations. And those employees who serve as grant makers within the organization also have to follow the policy because the nonprofit rightly believes that there are some potential conflicts there. So if you have a policy, what are the procedures when there is a potential conflict? Well, there should always be a duty to disclose all actual or possible material, direct or indirect conflicts and relevant facts. In other words, disclosure, disclosure, disclosure. If you think there might be a conflict, disclose it. If you think there might be something important that people should understand, disclose it. And if conflicts are disclosed, make sure you handle them in accordance with the policy. Make sure that you respond to allegations of wrongdoing or conflicts that are raised after the fact. At this board meeting on Thursday where we are talking about conflicts, this new board member had raised issues, and now we need to discuss whether this board member is correct, that there was wrongdoing, whether we followed the policy, whether things should be, procedures should be improved, whether a transaction needs to be unwound. So what are the procedures when you have a potential conflict? First, you've got your full disclosure. The interested party should disclose what's happening, and then they actually need to leave the meeting. They need to walk away from the meeting so that the remaining board members can fully discuss behind that director's back all the information, look at comparables, decide whether they want to proceed, whether they should get bids from other parties, whatever the information is. So the interested party needs to disclose, the other directors need to discuss it, and then a decision should be made once the directors feel that they know the full scope of all the potential conflicts. And they've done the investigation they've needed to do, they've done the due diligence, and they've determined whether this is the best deal for the nonprofit or the right deal. I'm not sure it has to be the best deal. You don't have to take the lowest bid, for example, because you have a right as a board to make reasonable judgments, and the lowest bid is just one factor. So once you've done this, it's important to have good minutes for your board meeting that describe what you've done. There should be a reasonably detailed description of the potential conflict. And all the additional facts that were considered, that should all be in your minutes, as well as documentation of the absence of the interested party from the discussion and vote. So to answer your question, no, the interested person doesn't get a vote on this decision. They should abstain. And it's also important to list all the directors who voted for and against the proposed transaction. Many times in meetings when there's a resolution, you'll see it you might see in the minutes it passed. It'll say something like the resolution passed or the resolution passed by majority vote. Why in this case do you want to see a complete list of everyone who voted for and against the transaction? Why is that important? So you know they abstained? Yes, that is one reason. Who is the IRS or the Attorney General going to look to if there's a problem? Yes, it does. It gets back to shared liability. The IRS or the Attorney General is going to look at the board, and it needs to be clear who voted for the transaction and against the transaction. So certainly if you're involved in a board and you believe something is wrong, you want to make sure your objection is noted in the minutes. Does that make sense? Okay. There are a variety of resources for boards to learn, for people to learn about what it means to serve on a board. There is the Charity and Nonprofit Board Service in Washington State Guidebook, and there's a link to that resource right here. There's also the Washington Nonprofit Handbook, that can be found on the WACO website. There are also several ABA, American Bar Association guidebooks for nonprofit board membership. It actually is a very rewarding thing. It's just important to understand that as a board member, you do have fiduciary duties of loyalty and care and obedience, and that conflicts are a big issue, but if you follow procedures and act in the best interest of the nonprofit, you can stay out of trouble. May I answer any questions about this? So the duty of care means that you have a duty to be a good board member. You attend meetings, you keep confidential information confidential. You look at the 990, the annual information return for the organization. You give your time, talents, and resources to the organization. That's the duty of care. The duty of loyalty is the duty to act in the best interests of the corporation, the nonprofit. That make sure that what you're doing really is in their interests. So that's the duty of loyalty. The next question is, what happens if a quorum isn't met because board members abstain, or is that possible? So a quorum is met at the start of the meeting. So in the bylaws, it will say what the quorum of the board of directors is. And in the state of Washington, it can go as low as a third of the board, but usually it's a majority. And if it's let's say it's a majority quorum, then you next look at your bylaws to see what the rules say for how many people are needed to vote to pass an action. So first there's the quorum, how many people have to show up, and then the next is how many people need to vote to pass an action. And a lot of times what the bylaws say is that a majority of those board members present can pass an action. So if you have 10 people on a board and there's a majority quorum, 6 board members need to show up in order to hold the meeting. And if you have a majority vote, then 4 people need to vote yes. So if too many people abstain, then the vote won't pass. So did I answer your question? Oh, great. Next is there a problem with a director contracting with a family member's business for small jobs around the library? And the answer is that is a conflict of interest. Is it a problem? Not necessarily, but the board should be clear that these family members are responsible and maybe ideally get some bids from other people. So again, it's the board's job to make sure, first of all, it's the director's job to disclose the relationship, and the board's job to make sure that what they're paying for the family member's business for small jobs is reasonable. It's not inherently wrong, you just need to take steps to make sure it's reasonable. Any other questions? Fabulous.
Well, thank you for, this is Diane Hutchins, and I learned a lot from this morning's session. I really appreciate all the things that you shared. This has been fantastic. So thank you very much, Laurie.
Hey, thank you. This has been fun.
I concur. That was a fantastic amount of resources to pack into this amount of time. Thank you.
Thank you very much.
A fantastic amount of information is what I meant to say.
It looks like there's a question from Teresa. She's asking if a board makes a bad decision, the person who abstained will not share liability. Should legal action be taken because of the decision?
That is correct. That doesn't mean that you should abstain from everything, but if you as a board member really think it's a bad decision, please do abstain. Make your voice known. Make sure that gets reflected in the minutes, because then if the AG's office or the IRS comes a knocking, you will not be held responsible. Any other questions? I really appreciate talking with you. If you do have questions, let me know.
Corinne has her hand raised. I don't know if she wanted to say something or what. Oh, she lowered her hand, so I guess not. All right, well, thank you everyone for joining us. You can just click the X in the upper right-hand corner to exit the room, and I will get the archive up as soon as possible for those that wish to review it. There are more archives available on our First Tuesdays website as well if you want to go through those. We have, I think, about 6 years worth now.
Thank you. Bye-bye.